the modern day ADR. They are the elders in the society, not necessarily by age, but those who have the wisdom, those who have the understanding, those who know how to settle disputes in a way that things will, people will continue to remain as neighbors, and they can live in peace. Not those who will hold very rigidly to some principles and say, no, it is this man's right and it must be enforced. So they are chiefs and their family heads who are respected within the community, within the society. And let's keep in mind that, sometimes people need to forgo things. It's a give and take thing on both sides. And there's no winner in any case when you come to the customary ADR. It's a case of having just creating peace rather than somebody going away and saying, yes, I have won. So those are things that, that we try to ensure, during the customer, in the customer ADR process. Now, however, we also recognize the fact that we must blend this with the modern ADR processes. We learn the best practice from the modern ADR and then see how we can imbibe this as part of what we'll use in resolving issues within this community. So in the customer ADR process, what are the things, what are the process? First of all is initiation. Somebody who feels aggrieved, somebody who feels that he has been denied, he has been cheated, will bring a petition to the palace and will forward it to the ADR center. And then both parties are invited. So both parties are invited to state their own parts of the issue. Now, keep in mind that sometimes, and I'll come back to this in a while, some of the parties who may think that, oh, they want to insist on winning, they may bring lawyers. We all usually discourage this from happening. So, well, no, we don't want. You are the one who is involved in this directly. So you have to state exactly the way it is. You don't need a lawyer. You don't need somebody to help you explain what has happened. This is not a legal court. It's not, a law court. This is also a mediation center for peace students. So we try to persuade people and discourage them from coming along. The lawyers can stay there and provide guidance to them, but we ensure that it is a petitioner and the person who petition was brought against, who directly speak to the issue at hand. And then when there's an agreement, and we try to ensure that we don't have more than 2, maximum 3 sittings before we come to a resolution. Once there's a resolution, we now have a written agreement which both parties will sign. Whatever the agreement is, they sign, and then we take these agreements to the multi-door court here in Abeokuta. And once it's been signed and stamped by multi-door court, it now has the force of the law in the implementation of that agreement. It now becomes an agreement that is legally binding on both parties. So this is how we try to blend the customary practice of mediation with the modern ADR process. And our ancestors used to practice, in those days, of course, the village head or the king has that authority to enforce whatever the agreement or resolution is. But these days, we have to rely on the multi-door court to support us, so it has the force of the law, to do this. And it has worked for us a lot. So here is a breakdown of some of the issues that we've resolved in the last 2 years. We effectively commenced ADR within the Owu Kingdom in 2024, January. And within that year alone, in 2024 alone, we managed to resolve about 18 cases successfully. Some of these cases date back more than 20 years. More than 20 years, some of these cases. Interestingly, in one of the cases that we handled, one of the issues that we handled, the president of the multi-door court here in Ogun State happened to be a party in one of those issues. And I had a discussion with him. It's a very interesting thing. He came around for a different purpose on another occasion, and he mentioned that, he was actually he attended one of the area processes where he had also to contribute, and actually enjoyed the whole session. And I told him, yeah, well, thank you very much for that. Justice, he's a retired justice, by the way. So I said to him, can you please um, tell us what areas you think we can improve upon, given your experience, given your knowledge about all of it. And he said, oh no, what he found interesting was that rather than having just one person sitting to listen to the whole thing, we had a team of people, like 4 people who were listening. And I said, yes. And that's the way our forefathers should do it. It's not just one person. You have a team of people, like 4 people who listen. And these are the neutrals. And then, they can then, compare notes. Somebody can see from one perspective, another person see from another perspective. But by the end of the day, they will all come to a common agreement on how to resolve that issue. And he said he found out a very interesting way, to manage some of this. And he said he really liked that a lot. So again, you can see from the plots, from the graph you have on the screen, if you can see my screen, that out of 28 cases, the large majority are actually land disputes. Not surprising. A few of them are, within association, trade association. One or two have to do with businesses. Another one with inheritance. Another family issue. Then ball issue, that's village head issue. So these are the range, but the large majority is about land. So we still have about 32 pending disputes that we're still managing, but primarily, again, the large majority of these issues are land matters. Interestingly, most of these land matters are within compounds, what we call agbole here in the southwest. That is, a compound where you have different families who are living together. And some of these compounds, the families in that compound may have grown to become very large. Then, of course, you can then imagine the friction when people want to begin to use, when this land space is becoming a premium, then usually you have this kind of, friction within family. But then again, these are something that we are still managing, and it's worked very well for us. And the feedback we've received from the people who have been part of this ADR, who have been part of the process, is that yes, they do like the way we handle it, the fact that we're blending the modern ADR methods with the traditional method of handling most of these issues. The feedback has been mostly positive. But however, there'll still be some who feel that, oh, they should have won rather than the way it went. But then in all of the cases, they all signed to agreement that yes, they agreed to the resolution method or the agreement that the neutrals had proposed to them. So let's come to mainstreaming of the customary ADR. First, we know that Nigeria's national policy on arbitration and ADR has now integrated ADR into our justice system. And this has happened quite well here in Ogun State. And as I must say that we received some very good amount of support from our multi-door court here in Abeokuta for our system here. And we have also had some training from them as well to support neutrals in modern day ADR process. So that has been working very well for us. The other thing is the need to establish ADR centers in rural areas, because that is where it is mostly needed. This is where some of these conflicts, disputes arise, and most of them will find it difficult to come to the city to bring the issues there. It's quite some distance to the city. So we're trying to establish this, the ADR center in a lot of the remote areas outside of Abeokuta, where we believe this will be needed, and will serve a good cause. The third bit being that they need to train mediators, the neutrals, as I say, for them to build capacity in the modern day techniques and then local customs, and to let them know very clear that, look, the integrity that they demonstrate, the fairness and just they demonstrate, and the focus on ensuring that peace is what guides, establishing peace, what guides the process and their decisions and their, how they go about it is also very important. The mindset that they go with this, mediation process is very, very key. And also part of the thing that we try to keep, focus on during the training. And we keep reminding them that, look, it's about establishing peace, not somebody's right or not somebody winning. No matter how important a person is, no matter how powerful the person is, it's about achieving peace rather than somebody winning. Somebody may win during the process, but then the problem that comes out of it may be much larger than what the victory that person has achieved during the process. So imagine a Nigeria where disputes are resolved very quickly in a cheap manner, because when they come, they probably just pay 5,000 naira to register their issue, and that's all they pay, except when they have to go to the multi-door court to have the agreement endorsed. That's the only time they pay whatever the multi-door court charge. 5,000 naira upfront to bring in the case, and then to pay to the multi-door court for endorsement of the agreement. I mean, that's very cheap compared to the case where they would take themselves to the police station, take them to the court, and I know you lawyers, I mean, it's important for you to earn a living, which we agree, but then there are a lot of other things you can do that will, engender peace and will bring justice in the system, and that will help us a lot. So again, it's part of the thing we're trying to, now, of course, there are a number of challenges and there are a lot of opportunities in the modern customary ADR process. One of the things we have found as a major challenge is the fact that there are some people who believe that, their rights must be enforced, they must get their rights, and they want to insist on bringing lawyers. So this is one of the major challenges that we usually have, which we try to talk. But the thing also being that once they hear that it's the Olowu who has invited them, it cannot, because out of respect and reverence for the stool of Olowu, they usually come and kind of calm down a bit. But again, you can tell that most of the time, and there are people who will be very selfish in their worldview, who will want to, even when they know they are not right, but because the person that they are contending with is someone they feel that they have a lot more influence over. They have a lot. They may want to get their way, but then because of the influence of Olowu and also the respect for the stool, most times we manage to get them to understand the importance of going through the process without them insisting on legal processes. Then training gaps. A lot of those who have been involved in the customary mediation process, we need to get them to be properly trained. And the training is not cheap, by the way. Some of them sometimes see things different from the way the modern day ADR works. And it's usually a challenge to help them to recalibrate their mindset, to help them to retune their thinking around how mediation should work in a way that will help them blend the customary mediation process with the modern day ADR process. The other bit is about enforcing some of these, agreements in rural areas. We can have the agreement endorsed by the multi-door court, but then when they go back to their villages or their towns outside of Abeokuta, ensuring enforcement may also become an issue, which is one of the other things, one of the challenges we still face. But all the same, these are not insurmountable challenges, but then there are things that we can still they're very small compared to the opportunities and the value of the process. Again, opportunities. One of the key things is the effects of decongesting the judicial system, which is currently overwhelmed. It eases the burden on the judicial system, the court system, and in fact, most times when you go to the court, you find that most of the judges will always ask whether the people who have brought the matter have, explored the mediation first. And each time the mediation, is brought up as an alternative, and they say yes, they are happy with that, the judge usually mostly refer them to mediation, and that's a great opportunity for us to reduce the congestion in our legal system, in the judicial system. Of course, building peace in the community is a major one for us. One, because any community that does not is not peaceful, that they can't work in harmony, there's no way that it can progress. It's just not possible. One of the things we found out. Again, it's about regional leadership. If we're able to institutionalize this properly and entrench this into our system, it will make us a regional leader as Africa's dispute resolution hub. And I think that will say a lot for us, apart from the fact that it will also will have helped in our society. Again, customer ADR is not a relic of the past. It's something that our forefathers and our mothers had practiced for generations, for over 1,000 years, here in the world at least. And it has helped us to build our community and our society and keep ourselves together as a community that's cohesive. Peace is costly in the sense that you have to compromise. You may have to compromise some of your rights, some of the things that you hold dearly, but then once both parties in the dispute agree to give and take, the cost is worth it, because the peace that comes with it, the benefits to society, is well worth it. Of course, true peace often requires efforts, sacrifices from both parties, but then that compromise really brings a lot of value to the community as a whole, eventually. Again, thank you very much. These are just the short things I just want to share with us, and I hope you find this useful. I'm happy to take questions or comments and even, suggestions on how we can continue to improve on our customer ADR process. Thank you very much for your attention. I wish you a very happy, productive session.
Thank you so much. Thank you, His Royal Majesty Obasakama Temilola, the Olowu of Owu Kingdom. Thank you so much. I can see the accolades, the comments, and the very kind appreciations of our participants in the chat box. Thank you so much. I also can see a few questions, but the plan is so that we can maximize time, subject to your convenience, Your Royal Majesty. If you will be here till the end, we want to take all the questions at once, if that's convenient for you. But if you have to leave, I can just read out the questions for you and then we proceed.
I'm happy to stay until the end of the session. If you just read out the questions, I'll just take them down and I'll try and address them as best as I can. Hoping I can answer questions from lawyers and judges, huh?
Thank you so much, Your Royal Majesty. Thank you so much. So you can start. You can stop sharing your screen now.
Okay.
Yes. Okay.
There we go.
Then, very quickly, we will proceed to take our next speaker, who is also on the call. Our next speaker is, our next speaker is Honorable Justice Veronica Ngozi Ume. Honorable Justice Veronica Ngozi Ume, retired LLB, LLM, Fellow of High ADRN, and Fellow of ICMN. Honorable Justice Veronica Ngozi Ume was a judge of the High Court of Anambra State of Nigeria. She holds an LLB degree, University of Nigeria, LLM of the University of Calabar. She is a fellow of the Chartered Institute of Arbitrators of Nigeria. She was called to the Nigerian bar in July 1978 before being appointed to the bench. She sharpened her legal skills at the Chamber of Akpamgo and Akpamgo SAN, barristers and solicitors, and GE Ezeuko SAN and Co, solicitors and advocates, respectively. His Lordship joined the Anambra State Judiciary as a magistrate, where she rose through the ranks from Magistrate Grade 1 in 1982 to Chief Magistrate Grade 1 in 1997. Honorable Justice V.N. Ume was elevated to the High Court bench on 17 September 1998, and since then has presided in several judicial divisions in Anambra State Judiciary and was the administrative judge in charge of Onitsha and Otuocha Judicial Division of the High Court of Anambra State, respectively. His Lordship retired as a High Court judge of the Anambra State on February 24th, 2014, after more than 30 years of meritorious service to the Anambra State Judiciary. As a retired judge, she served as a delegate under the judiciary in the National Conference in Abuja in 2014. She has headed many panels and tribunals in Anambra State. This includes the Oko Community Crisis, from October 2014 to April 2015. Unado land crisis, Omo Igboku land crisis from 2018 to March 2019, and concluded with the Federal SARS Investigative Tribunal on Police Brutality and other related matters in March, from October 2020 to March 2021. Distinguished ladies and gentlemen on the call, please make welcome my Lord Honorable Justice Umbe. My Lord, you have the floor. You can unmute your mic. My Lord, can you hear me? If you can hear me, you can unmute your mic. Okay, so yes, you're a co-host, so you should be able to unmute your mic. Oh. Okay, looks like my Lord is having technical glitch. I don't know if anybody else can hear because I cannot.
We cannot. I cannot.
Okay, thank you, Prof. So it looks like she's having technical glitch. So maybe we'll just very quickly, to save time, move on to the next speaker, who I also believe is on the call. And that
Hello.
will be
Professor Kamal is with you.
Yes, I'm aware of that, Prof. And you'll be the next speaker. So while we're waiting for my Lord to probably resolve the technical issue she might be experiencing at her hand, we'll just move on swiftly to the next speaker, Professor Kamal Dawood, LLB, LLM, Fellow of the Chartered Institute of Arbitrators. Professor Kamal Dawood is a professor of comparative constitutional law at the Faculty of Law, University of Maiduguri, a specialist in ADR, and a trained expert in high HL. He was the Dean of Law, Faculty of Law, Islamic University in Uganda, and a visiting lecturer at the Kampala International University, Uganda. Professor Kamal obtained his LLB, Sharia, from the University of Maiduguri, and had his LLM and PhD in law from the University of Jos, Nigeria. He has published widely, nationally and internationally, and has attended several workshops and conferences, both nationally and outside the nation. His areas of interest are Sharia, comparative constitutional law, international humanitarian law, and human rights law. He has taught law for about 24 years and is also practicing. He is the principal counsel at Musawa Chambers in Maiduguri. Ladies and gentlemen, please welcome Professor Dawood. Prof, the floor is yours.
Thank you for having me. It's all about ADR, an alternative to the formal court system that we have to go for because of its simplicity, not too technical, very reasonable. And because of the fact that our party owns the process from the beginning to the end, and the procedure is been set by parties. So it's easy for parties to now go for ADR as an alternative for the government court's adjudication. Long before now, we all know that before the modern alternative dispute resolution, the traditional society have their indigenous methods of dispute resolution, where, as the first presenter said, the family heads, elders of council, chiefs, religious leaders, and the community-based institutions that assist people to resolve the issue, assist in bringing an end to dispute. But even with the modern day ADR, we notice that the Nigerian justice system has imbibed the ADR system. The court encourages settlement out of court because the fact that cases are too much before the courts. And once parties say, my lord, we want to settle out of court, the court will always encourage settlement out of court. And before you know it, the court will, at the end of the day, allow the decision of parties, maybe enter consent judgment in favor of parties. And honestly, we have to have it at the back of our mind that what the colonialists brought for us was good, but we shouldn't throw away what we have before they're coming. And what we had before they're coming is the traditional, customary alternative dispute resolution, which is very indigenous, it's community-based, and it resolves matters fast, easier, and better than the judicial system that we have. A story of a man that have a case before the area courts here, from the area courts to the Supreme Court, and back again for the trial by the order of the Supreme Court to the area court, and goes again to the Supreme Court. The person that started it died. His children died, leaving the matter for the grandchildren to conclude. And at the end of the day, the grandchildren concluded agreeing on ADR, which we had it been they started with ADR at the beginning, it wouldn't have reached the extent of generations of family trying to see that they got justice through the judicial system. In Nigeria, we will agree that we have a lot of spectrum of ADRs mechanism, very diverse, that gives pathway for parties to resolve their dispute amicably and efficiently outside the conventional court system. And the customary ADR is one of the 5 windows. The customary ADR, we have a negotiation, mediation, conciliation, arbitration. Arbitration is more formal. Negotiation could be between 2 parties. They will negotiate, and at the end of the day, they resolve their matter amicably. Mediation, unlike negotiation, involves a neutral third party that will assist to facilitate the communication between parties with a view to see them come to an agreement. Conciliation is another method and another window, which is very similar to mediation. You still need a third party neutral to assist you to settle or reach an end to settlement. Arbitration is more formal, as I said earlier. But coming back to customary dispute resolution, we look at it, or I look at it in 3 ways, looking at the 3 regions, the north, the southwest, and the southeast. Each of them have their own peculiar ways of resolving matters. In the north, majorly, we use the tradition, which is part of the religion, the concept of sulhu. Sulhu is amicable settlement. You can look at it as a way of negotiating as well. You can look at it, and as a way of mediating, you can look at it as a way of conciliating. It's different from arbitration. Arbitration is called tahkim, which is quite different. The origin of sulhu is it has to do with the religion. It has its basis from the Quran and the Sunnah of the Prophet sallallahu alaihi wasallam. If you look at the Quran, Surah Al-Hujurat, verse 9 to 10, and you look at Surah Al-Nisa, verse 129, and you look at Surah Al-Anfal, verse 61, all encourage sulh. The Prophet ﷺ will always say that sulh is best. What sulh khair, that sulh is best. And it's easy, it's simple, and it's religious. when you say people go and mediate, and you use the word sulh, go and do sulh between yourselves. They find it as if it is an act of worship. So they accept it. The acceptance is there because it's part of the religion, and it has become part of the custom. So the Prophet ﷺ encouraged sulh, and the people after him, that is the companion to in their affairs, try to use sulh to resolve amicably matters, particularly matters that has to do with between individuals, matters of marriage, contracts, and the like. The first presenter was talking about issue of land. It could be resolved by way of suit. It's about give and take, and at the end of the day, the two parties will go home win-win. Nobody will say, okay, I've lost, and nobody will say, I've win, because they take it as part of tradition and take it as part of their religion. Honestly, if you look at the society in the North, it's well structured. You want to start from the bottom, you look at the ward head. The house of the ward head is always like a court where people bring matters, and for the ward head to assist them in amicable setting. And mostly the principle of sulh is what they use. Give and take. How can we see or bring an end to the dispute of any kind, honestly, of any kind? It could be resolved. And not only through the what else, the village heads, they apply sulh too. And the village head is as well answerable to the waziri, for instance, in the case of Borno. And I know no issue will be so difficult for all this category of people that it would reach the palace of the Sheikh of Borno. I don't think so. But if it reaches that stage, of course, the Sheikh will intervene, and what you will first look at is how can this matter be amicably settled through the principle of sulh. The procedure is simple. When you talk about bringing matter before the ward head of the village head, yes, the complainant will come orally, not filing anything, orally stating complaint, and he has to state against whom is he making the complaint, and easily the ward head of the village head will order that the person be called, and that person be called, and that person will be asked to answer to the claim of the claimant. And if it is one that is settlable, it will be settled by the principles with using the principle or using that window of sulh. And as I say, it's enforceable because once you look at it as a responsibility, once you look at it as an obligation, religious obligation, and it's easy for it to be enforced. Of course, the first speaker has talked about ADR as it obtained in the north, southwest, and I think, my lord, the second speaker will be looking at the ADR, considering the tradition in the south or southeast. But honestly, traditional alternative resolution, dispute resolution in Nigeria is so vibrant and deeply rooted in resolving matters, and it has been employed, and mostly in the north, the alkali courts, the Sharia courts, the area courts, they encourage people to go for it. And you make sulh outside the court, you bring the resolution to the court, and the court adopts it as a consent judgment. I think with this, I will be expecting questions from people, so that from the audience, so that I will be able to expatiate more. Thank you for listening.
Okay, thank you so much, Professor Daoud, for that very short and succinct presentation. Okay, so now we'll get back to my Lord, Honorable Justice Hume. My Lord, you can unmute and speak now. My Lord, can you hear me? Okay. Okay. So while we're still waiting for my Lord to unmute a mic and speak, we're just going to dive straight into the next presentation. And I will be sharing the profile of the next speaker very shortly. Just a minute, please. Okay. What? The next speaker on today's webinar is Professor Akinola Ibidapo-Obe, FIADRN, FICMN. Professor Akinola Ibidapo-Obe is the President and Chairman of Council of Institute of Alternative Dispute Resolution, Development and Conflict Management of Nigeria Limited Guarantee, IADR Nigeria. He obtained his Bachelor of Law degree, LLB, from the University of Lagos in 1977 and was called to the Nigerian bar in July 1978. He obtained his Master of Laws, LLM, degree from University of Ile-Ife in 1981 with distinction. Ibidapo-Obe began his academic career as a lecturer grade 2 at Obafemi Awolowo University, Ile-Ife in January 1986 and subsequently transferred his service to the University of Lagos in January 1989 as a lecturer grade 1. He was promoted professor in 2011 and was elected Dean Faculty of Law and served between 2014 and 2016. Ibidapo-Obe was until 2023 a member of the Governing Council of Nigerian Institute of Chartered Arbitrators, NICAB, on which council he served for 5 years, winning the prestigious Chief Afe Babalola Award for outstanding contribution to the development of the institute. Ladies and gentlemen, please make welcome Professor Akinola Ibidapo-Obe. Prof, you have the floor.
Thank you very much for having me. The topic of my discussion is integrating customary arbitration into formal arbitration processes in Africa, prospects, modalities, and challenges. May I respectfully acknowledge our previous speakers, in particular, His Royal Majesty Obama Temilola, of whom I've heard so much about his initiatives concerning customary arbitration. So we are highly honored to have him to talk to us about some of the things he has been doing. And of course, I greet my very dear colleague on the council, Professor Kamal Dawood. So I go into my lecture now, and the idea really is that I remember having the discussion with some of my friends, and I was insisting that we should call customary arbitration what it is, arbitration. The moment we start to say customary ADR, then in my own mind, it appears as if we are now saying that it's an alternative. The original method and mode of conflict resolution in Africa cannot be the alternative. It is the modern one, the modern arbitration processes that are alternatives to the original. So with greatest respect, I want to advance the thesis that customary arbitration should be called by its rightful uh, nomenclature, which is customary arbitration. If we say customary ADR, then we are implying that it is subservient, so to say, or secondary to modern arbitration. So this is the system that we have been using. And up till now, according to statistics, about 80% of all disputes which arise within the communities of Africa are still resolved by the traditional rulers, by the traditional institutions, by the elders, and in the communities that are horizontal, like the Igbo communities, by the age grade associations and so on and so forth. So uh, we all know what it entails. That is customary arbitration. That is disputants. The parties to the dispute will take their dispute to the elders, submit the dispute. The elders will invite the contending parties and they will go into the dispute and make inquiries, and each person will try to present his own case. And at the end of the day, the traditional authorities will come down with a decision which is binding on all the disputants. They will go home. I do recognize that the philosophy behind African arbitration is that it's reconciliation. So I am on the same page with His Royal Majesty when he says that it is not a winner takes all kind of outcome. It's a matter of one party giving a little, the other party giving a little, so that both of them can walk away from the meeting and say, yes, we are satisfied. And that outcome will only come if both of them feel that at least part of their own interests have been taken care of, part of their own fears have been allayed by the decision. So it's a winner take, so it's not a winner take all situation. So what we are really thinking of doing, and I must say with all due regard that of all the arbitral arbitration institutions in Nigeria, and there are quite a number of them, our own organization, which is the IADR Nigeria, which is the shorting form for Institute of Conflict, Institute of Alternative Dispute Resolution, Development, and Conflict Management. It's because it's a mouthful. That is why we have abbreviated it to IADR Nigeria. We are the first and only institute, by my reckoning up till this point, to have included customary arbitration as a department of our institute. We are hoping to build a vibrant customary arbitration framework and network that we are hoping, working with other stakeholders like the traditional rulers, that we are hoping to ensure that it becomes part of the mainstream. By mainstream, I mean that it should be part of Nigerian laws. The institutions should have some connection. That is, arbitral institutions and the customary institutions must be connected in a way that will make them to work symbiotically. This is what we mean by, and then the procedure for doing customary arbitration and for arbitration in general, there must be a way to make them to be fused. Maybe not that you will not be able to identify which is which, but fused means that they should be able to work together without any conflict of any kind. So what I've done here is to look at Ghana, look at South Africa, and look at Nigeria and see how Ghana and South Africa have been able to arrange their customary arbitration, system, and then we compare that to Nigeria, and then we look at which is best and what we can learn from South Africa and from Ghana in ensuring that we achieve these mainstreaming that we consider to be imperative to make arbitration a proper alternative to litigation. So what we have in South Africa, for example, well, maybe I should look at, apart from the history of customary arbitration, let's look at the differences between customary arbitration and the formal legal system. When the first difference is that one is formal, one is informal. Customary arbitration is informal, whereas arbitration is formal and rule-driven. And then in customary arbitration, there is lack of documentation. Although, as we can see, there are changes being made in that department, perhaps with the initiative by Kabiesi Matemilola, but in the traditional sense, nothing is documented. There will be discussion, there will be decision, and so on and so. But as we go along, maybe these are some of the things that we need to look into and ensure that we can change so that we can achieve the mainstreaming that we want. The other difference is representation. Lawyers are typically excluded from customary processes. And then, of course, the legal status. There is formal arbitration, which is recognized by the statute. And there is customary arbitration, which is recognized only in the sense that their decisions are validated by judicial precedent. In other words, once it is challenged, then it stops to be valid until the court now pronounce that yes, what you have done is okay. As Professor Kamal pointed out, this could take years. If there is a challenge, it could take really years and decades for that particular decision to be validated, which is also another point of a problem. Now, what are the differences? What are the similarities? We have looked at the differences. Well, the first thing is that both of them are party-driven. People must voluntarily submit their dispute to the traditional mediators. Then, of course, we have a neutral panel or a neutral person deciding the outcome of that dispute. That's another point of convergence, another point of similarity. Then, of course, the emphasis on reconciliation. I believe that also to be why people go to ADR, because they want to continue the friendship, they want to continue the business relationship, and so on and so forth. So that's another point of similarity. Then, of course, the outcomes are binding. In customary arbitration and then in arbitration, the outcomes are binding because particularly if there is the parties to the customary dispute do not deny or do not oppose what the decision has been. So now if we go to the legal and institutional framework, what we see is that the governing statute when it comes to arbitration is the recently recent, as in 2023, Arbitration and Mediation Act, which is the binding instrument. So there is no recognition in that document, and I think is a very big miss for those who came up with the idea. There is no provision in the AFA to accommodate customary arbitration. All it takes is one or two sections and then one or two sections also in the rules to say, look, whatever decision has been moderated by traditional rulers or traditional institutions should be acceptable, particularly if they conform with A, B, C, D. That kind of those kinds of sections in the AMA will have immediately mainstreamed customary arbitration, but we lost that opportunity. I'm saying so because in the Ghana example, Ghana have a law that is called the Alternative Dispute Resolution Act of 2010. And in that act, I think is virtually the counterpart of our own AMA. There is an explicit acknowledgement of customary arbitration. And then there are outlines for its enforcement in that act. If the AMA had adopted the format of the Ghana law, we won't be here talking about mainstreaming. It will have immediately mainstreamed customary arbitration. We are still hoping that sometime in the future, as we look to improve our ADR system, as we look to decongest the courts, we may still have to go to the option where arbitration and ADR will be seen as a very large umbrella that has the ability to also incorporate customary arbitration within it. So what are the modalities for integration? Because this really is the key. We have had customary arbitration for centuries, and we are still having customary arbitration even as we speak. How do we make sure that there is some form of integration between the normal arbitration system and our customary arbitration? One of the modalities is legal recognition, as I've said, just like in Ghana. This will mean, for example, in Nigeria, that the AMA is amended with the addition of certain sections that will recognize the customary arbitration, and then the addition within the rules that will then say, well, if customary arbitration is conducted in this and that a way, then that should also constitute a binding arbitration. So we are looking at legislative recognition. And then we can look at certification and registration. You see, our own institute, IADR Nigeria, we have a certification procedure whereby after a course in customary law and arbitration, because both of them are fused, you will then get an advanced diploma in customary arbitration. It's the very first of its kind. It is the only way, or is one of the ways that we see at our own institute of bringing customary arbitration into the mainstream. Once these practitioners are trained in modern arbitration methods and they have their traditional skills, then all the problems or all the reservations we have about whether they are human rights compliant or not, all those will be obviated. So what we do, and our institute is the only one of the more than 30 or thereabouts institutes that have been registered in Nigeria. So this is an important, so we need to continue to certify people. It's not that they are not competent. What customary arbitration gives you is your native intelligence, your sense of justice, and your sense of fairness. But what a little bit of training and certification will do is to now add further skills of arbitration methodology, of coming down to decisions and so on and so forth. It will add that to the portfolio of the practitioner, and it can only improve the quality of decisions that come from our customary arbitration panels. So the third one is, of course, we have said certification of customary arbitrators. Then, of course, we continue to train. We train them in ethics, record keeping, human rights, and procedural fairness. If many of them are already familiar with such things, because we too have human rights sensibilities within our own cultural framework, all the better so that it won't come to them strange. They will now know that what they know as traditional arbitrators about fairness, about justice, is the same thing that the modern system is trying to sell to them. Then this is one of the suggestions that it might sound strange, but if we look at it, there's nothing wrong. What is wrong with when we have a very intricate arbitration matter, and we have said that, and for example, our institute has been asked to nominate a panel of arbitrators. What is wrong with appointing an Oba Matemilola as a member of a three-man panel? He will bring his own training. He will bring his own education. Mind you, these days, many of our traditional rulers are quite well-read. It might not be to the level of a professorship like Kabiesi, but many of them are graduates. Many of them are well international persons and well exposed. So what it will do is it will enrich that panel, and that panel will then be empowered and able to look at the most intricate disputes and come to a decision. I was amazed when I did a research for the British Council in 2014, and we did a research into Ijora Kingdom in Lagos. We discovered that under the king of Ijora, the Ojora, there are 21 ballets, 21 in all the areas. Surulere is a very large, you will know it. It's a very large kingdom stretching to Surulere and all those places. There were 21 ballets. And one of the ballets who was sitting in Apapa, where they have tank farms and so on and so forth, I was there physically when he was able to resolve a dispute over a tank farm running into millions of naira. And I'm talking about a ballet that if I recall, is not even a graduate, but is maybe a school start person, but he had all the understanding and all the information, and he decided, and both of them were very happy with the decision. So my point really is that there is nothing wrong with experimenting with hybrid tribunals. Hybrid meaning that a tribunal that will consist not only of certified arbitrators, but also of traditional arbitrators who are competent and who can bring their own skills and knowledge while they learn from the skills and knowledge of the other members of the tribunal. We're talking about mainstreaming. There are many ways to achieve this. I've mentioned 4 or 5. Then we can then say, well, whenever the customary arbitrators come up with a decision, there should be a body to oversight their decisions. Because right now, once those decisions are made, Obama Temilola's idea of taking it to the multi-door courthouse is very unique and very innovative. At least it will go to the MDC multi-door courthouse by way of an agreement which the multi-door courthouse will ratify. Well, I'm thinking of a similar situation where there are oversight bodies, but this will not be judges. This will not be judges who will come into it with a judicial mindset. This will be customary arbitrators, maybe also, but it has to be recognized. So if there is any decision from the traditional courts, it comes to this appellate traditional tribunal, as I will call it. And then, of course, that will give room for review, that will give room for improvement, and that will give room for us to create precedents on these kinds of. Then, of course, by way of another suggestion, institutional integration. That means that we should incorporate customary arbitration centers into national ADR institutions. This is exactly what we have done. This is exactly what IADR has done. We have now incorporated customary arbitration into a formal ADR institute as part of our departments, well staffed with a panel of neutrals who are traditional rulers, well enlightened, well exposed. I think this should be a model for other institutes. We are the only one that has done this. Now, what are the prospects and opportunities? Well, the first thing, of course, is cultural legitimacy. I always feel sad when I now listen to people and they are letting it appear as if, oh, they are bringing arbitration to us. It was founded by Professor Sanders of Harvard and so on. When I hear such things, I always cringe. Professor Sanders did not create arbitration, did not create mediation. These have been part of the African dispute resolution profile for centuries. So we need to bring cultural legitimacy and public trust into the system. Then it's cost effective. I was very happy because as Kabiyesi was giving his lecture, I was wondering how much does it cost? And he answered the question, 5,000. That's it. That's very reasonable. If you were to employ the formal arbitrators, depending on the dispute you are bringing, sometimes it runs into millions. So, and if we are going to service the underserved, the rural people, then we should be thinking of a cost-effective method. Then, of course, the deep penetration. Look, people always assume that Lagos is Lagos and Port Harcourt and Aba, the metropolis, that this is where only dispute arise. No, dispute arises every day in all the nooks and crannies of the country. And that means the rural areas where 80% of our people live. If we now mainstream customary arbitration, then what that means is that there will be deep penetration in the rural areas. Then the courts are congested. That is an automatic advantage. And then, of course, look, we have to be Afrocentric in everything we do. We are African countries. We should not continue to be copycats. Let us develop our own system and take that to the world marketplace of ideas for them to say, yes, this makes sense. So we have fostering an African-centered arbitration jurisprudence. The challenges, well, lack of legal clarity and statutory basis. This is what I am hoping that we can, maybe when the AMA comes up for review, let us find a way to incorporate customary arbitration. If Ghana can do it since 2010, I don't see why we cannot do it. So, visibility and inconsistency of customs. Well, I don't believe that that is a very big problem now because we have so many books on customary law, on traditions that we can borrow from, that we can learn from. So then, of course, there is the risk of capture by politicians, and you know, the Kabiyesi was talking about the dispute between the that politician was godly. He didn't want to raise any problem. That's why he gave that leeway to the person that had brought the case. But what if we have politicians that try to affect decisions of customary arbitration negatively, that try to influence it with money and so on and so forth? But I do believe that the traditional institutions have their own inbuilt cautionary methods. If we are going to be swearing an oath before the traditional gods, you are not likely to start telling lies and misbehaving. Uh, these are the traditional, if you like, safeguards that are already in place. People talk about human rights concerns. From the research I did for the British Council, along with the team, I just led the team of about 7 people. What we found was that the customary arbitrators have a very sound idea about human rights, fair hearing, Nemo Judex, you can't be a judge in your own cause, and so on and so forth. They have that understanding. So it's not going to be a difficult thing to upgrade them and sensitize them. Then, of course, inadequate documentation. One of the things that our institute is hoping to do is to find support, and we are happy to work with all bodies, and I believe KBAC Matemelola's initiative is the most outstanding. Let us get some people, local government people, to say, look, let us equip traditional courts. Let's start with the first class obas. Give them secretaries, give them computers, give them recording equipment, video recording equipment, and so on and so forth, so that they can at least record their proceedings and decisions. And then what do we do in arbitration? We don't start to write anything in long run. There are recorders. We invite people, ethnographers, who will come in, and then they will then give us a transcript. We can do the same thing with customary arbitrators. Invite people with equipment. They will take the proceedings and produce transcripts of that, and whatever decision it comes to, people can then have the transcripts. It's what we do, and it should be extended to the traditional institution. So we come to comparative insights now. We have seen that Ghana has really done. In South Africa, what happens in South Africa is that their constitution recognizes traditional rulers. Our own constitution does not recognize traditional rulers in the way that South African, to say that these are traditional institutions. Our constitution recognizes local governments and so on and so forth. We should let them see that community leaders who have been selected to be paramount rulers and chiefs and so on and so forth, they are part of the administration of a justice system, and they should be recognized by the constitution. Our traditional rulers have been crying to Abuja every now and then. They have not been able to amend the constitution to recognize the traditional authority. This should not be so. This should not be so. If we recognize police, we recognize judiciary, we recognize the Sharia court. And by the way, this is an important point. The customary court system that we have, at least in the South, is a misnomer. It's a misnomer because they are manned by lawyers who are not necessarily conversant with the traditional, with the customary law that they administer. They are not conversant. They are lawyers. And so once you are a lawyer, they say, oh, you can then be president of a customary court. What we are talking about here, about customary arbitration, is about the palace courts. And I want us to, I believe that's a proper name so that it will clearly distinguish the palace courts from the customary courts that we now have. Customary courts now, they're only good for collecting market dues, and then local government will take them there, and all those kinds of things. They are local government courts. We are talking about palace courts, traditional palace courts, where the personnel in place are the traditional rulers, the custodians of our culture, who are knowledgeable, not lawyers who have just been drafted, and they are now called president of customary courts, and they are alien. And don't forget, even in our universities, customary law is not. Look, I retired from University of Lagos after 37 years. We only introduced customary courts in 2016. Customary law, it's on the syllabus. It's on the syllabus, but there is a colonial mentality feeling amongst all of us who are academics. Customary law, what is there just legend and myths and so on. So we look down on our own law, on our own customary law. As a result, we don't have a core of people who are trained in customary law. This is a very serious problem for our legal training. And part of the things we have to do, and I have a recommendation here about academia, we should ensure. I started teaching customary law in the University of Lagos. The first time that we introduced customary law to level 3 students, I had more than 500 in a hall of that can only take two. They were sitting all over the place. The students are interested. The students are interested. It is we who are not able to give them what we want, to give them a syllabus that is Africa-centered. And I suggest that all universities must review this. The northern states are teaching Sharia law and they are implementing their own version of customary law. But in the South, we are miles behind, miles behind. So we have looked at the challenges, we have looked at the learning experience. What we learned from South Africa is that we should make constitutional amendments, accommodating, recognizing traditional rulers. What we learned from Ghana is that there is no big deal about mainstreaming customary law. All we need to do is amend our AMA to now include recognition of customary arbitration tribunals, and then we give them we provide rules that will guide the customary arbitration tribunals in handling their cases. Thank you very much for listening to me.
Thank you so much, Prof. Thank you for that very in-depth presentation. Thank you so much. It was very relatable, it was knowledge-packed, very insightful, and I'm sure that our participants are glad they are here. I mean, I can say that. I'm sure that our participants have gotten very good value for their time. So once again, I am going to see, we are trying to wrap up. So quick announcements, please. You can leave your questions and comments. I've seen a few questions in the chat box. You can leave your questions in the chat box. So, and preferably, if you'd like it to be answered by a particular panelist, you can direct it to the panelist that you want to answer it directly. While we're doing that, my Lord, Honorable Justice Ume, I don't know if you are able to unmute so that we can take your presentation very quickly and briefly before we go into the question and answer section. So my Lord, if you can unmute your mics, so that, okay, she's currently on the call. So, and she's a co-host, which means she's able to unmute her mic and speak. So I'll just wait for her. While that is ongoing, I will go quickly to the chat box and start with the questions while we're trying to do that. So I'm going to start from the very beginning because I noticed that the questions started coming in. Apologies, from when His Royal Majesty started speaking. So I have, okay. So a question from Iotu Edwin Inegidu for His Royal Majesty. The question is, how do you guide against bias on the part of the elders or mediators being bought by a party? So this is avoiding compromise. So His Royal Majesty, this question is for you, sir.
Okay, thank you very much for that question. See, one of the reasons why we are, can you hear me clearly?
Loud and clear.
Yes, we can hear you.
Very good. One of the reasons why we have at least 4 to 4 news in any sitting is to ensure that we don't allow any bias. Because most of the time, the neutrals are also, in fact, all the time, the neutrals are also from within the community. They may have some kind of affiliation or association with some of the parties in a way that the ADR may not be direct, but they may have some sympathy, for example, for the cause of somebody or the rest. Even though we try to ensure that such people recuse themselves when issues come up that affect them directly or that they are somehow connected to, there may still be an indirect influence But because we usually ensure that we have at least 4 neutrals, we try to get a balanced view. And in any situation where there may be a bit of tension in how to resolve the issue, they always defer to Olu. And I'll step in and ensure that, they're guided in a particular direction. So, as opposed to the regular ADR system, the modern ADR, where we have a single person. I know of somebody who is who sits in multi-door court. She just sits there all by herself, hears all the petitions, and then makes a judgment. So in our case, it's not like that. And that's one of the comments I made, when I was speaking, referring to when the president of the multi-door court, had to interact with us. One of the comments he made, and he referred to the fact that our system also tries to reduce to the barest minimum this kind of bias. Thank you.
Thank you so much, His Royal Majesty. There's a second question for you, sir. Okay, I'm still trying to find it. Yes, okay. So there's a second question. His Royal Majesty, may I respectfully ask that in view of the blending with modernity, do the chiefs have the opportunity for capacity building? I'm sure this person is asking, are the chiefs trained in the modern laws, in the modern AR laws and techniques, so that we're blending law with, we're blending traditional practice with the modern law?
Very good. So we qualified the customary AR activities in 2023. But I insisted that we must get training for the neutrals before the commence. And that was the kickoff until January 2024. And we had to get the NSCDC, the commandant in Ogun State, then who was freshly transferred to Ogun State, I think it was the early 2024, yes, happened to be somebody who is an expert in mediation and ADR. So, and he offered that his people would train neutral. So that's how we started. So they went through a full month training in modern ADR methods before we allowed them to commence the ADR sitting. So yes, they went through ADR training, and at the end of last year, I think it was early this year again, we also sent them on a refresher course organized by the multi-door course here in Abeokuta. So we do train them from time to time to ensure the modern ways and techniques and procedures of their system.
Thank you so much for that response, His Royal Majesty. Thank you. So, okay, so then there's a question from Felix Abiodun Akonde, and I will personally, it's not directed to any of the speakers, but I think I will direct it to Professor Akinola Ibidapo-Obe. The person is asking, how do you think lawyers can make money from ADR, as most lawyers need good living conditions? So I'm sure this person is asking, yes, how to make money from the practice.
Well, the simple answer to that is every lawyer must undergo certification. You have to be part of an institute where you will train as a fellow or as a member or as an associate. If you're a lawyer, invariably you have the requisite number of years, you can go straight to the fellowship. So if you are a trained fellow, what the institutions do is that they will now put your name on a roll, on a register of panel of neutrals. And when these cases come in, I believe that as time goes on, we will continue to have an increasing volume of referrals. When these cases come in, if you have paid your dues and you are, a member in good standing, then of course the referrals will. One of these days, you will also be nominated by the institute as a member of a panel of neutrals. And arbitration, as I said, in fact, one of the things that scare people away is the cost. But so the very one or two arbitration briefs, you will in fact want to continue to be an arbitrator. Not when you have a brief, it takes you 3-4 years to come to the end of the case. But when you do arbitration within 2 or 3 months, 2 million or more is sitting in your account. So that's how to make money. Become a certified chartered arbitrator. Chartered and certified meaning the same. We'll be very happy to welcome you at our institute, IADR Nigeria. But you can go to any institute of your choice.
Thank you. Thank you for that.
Honestly, regarding customary ADR in my area here, it's an act of sacrifice, an act of service to the society, which I know the wardeheads, village heads do without asking for money. So, but in a situation where it will be a bit formal, that is what the previous speaker is talking about. Thank you.
Thank you so much for that additional intervention, Prof. Then there's a question for His Royal Majesty here from Chinyere. His Royal Majesty, due to movement of persons and diversity of tribes, unlike before, how will the chiefs handle disputes from persons with different tribes? So I'm sure this person is asking if, for instance, you have people from a different tribe in your community who have moved there to settle. What law applies to them? How do you mediate in this case?
So it's not about law, it's not about tribes, it's not about custom. It's around how do we manage relationship in a way that peace will be maintained in the community. Of course, we've had a number of issues where disputants are not from quite. As a matter of fact, we have had petitioners who have come from outside of Abeokuta just because they have so much confidence and belief, and they've heard about our system here, about the fairness, about the integrity with which we go about it. So it has no correlation of tribe, no correlation of religion to it as well. I'm a Muslim, for example. I can't say, well, I'm going to impose the Sharia way of doing things. The Sharia way of doing it, of course, I don't have to. It's the way to do it, but then sometimes when people hear that their arms are up and they say, oh, no, they want to impose, but it's not about that. It's about how do we ensure that we resolve disputes in a way that will ensure that the litigants, the petitioner and the person whose case was brought against can still go back and live with that same community as neighbors, and that's what it's all about, really.
Thank you for that. Thank you for that, Your Majesty. Then there's a question here for Professor Dawood. And the person is asking, crime is said to be against the state and not against any individual. Why is it not allowed for the village heads or chiefs to administer justice to criminal matters such as murder, since they know more about their subjects?
Yes, the thing is that if you look at the setting before the coming of the European masters and the colonialism in Nigeria, they handle such cases. But with the coming of the English law, gradually, these powers were taken off the traditional rulers. And now it's the courts that now hear and determine all matters that are criminal in nature. So it's not one that the traditional customary ADR can look at or handle. It can never be. It's an issue of constitution, it's an issue of law, that crimes are to be tried by the state, not until when it has been changed.
Thank you. Thank you so much. Thank you, Prof, for that. Then there's a question by Abdikarim Kurama here, and I will direct that to Prof to Professor Ibida Pobe. Is asking, can customary ADR be adopted as consent judgment in the court of law? And if yes, which court has jurisdiction to entertain the matter?
Well,
Yeah.
this is one of the things I've learned from KBC
Okay.
Obama Chemilola. That
Mhm.
is, instead of taking the
Mm.
dispute, the hearing of the dispute itself to the multi-door courthouse or some other institution, the the customary arbitration will end in an agreement between the two parties, two disputants. It is that agreement that will be taken to the multi-door courthouse and even perhaps for enforcement in a formal court. Because once you have an agreement, it's the duty of the court to assist you to implement that agreement. So I have learned that now, that apart from listening to the something, that's a modality of mainstreaming customary arbitration. You let it end in an agreement that will be signed by the two parties, and then you take it forward to the multi-door courthouse or to any other institution that has the jurisdiction, so that it will not then be a consent judgment. So this is but I believe that for Nigeria, the beginning should be the, if you like, uh, amendment of the Arbitration and Mediation Act to allow for recognition of customary arbitration. If customary arbitration is recognized formally within some sections of the AMA, and there are rules made therefore, then just like when the two parties agree in an arbitration, the mediator or the arbitrator will then make that a consent award. So we can have the same thing, but I believe that the beginning will be that the AMA should please recognize, amended to recognize. Some of us wrote briefs in that regard when they were asking for commentaries, and I was at the Nigerian Institute of Chartered Arbitrators then. And apart from some of the other things that we recommended, I remember that this was a cardinal recommendation, but apparently we did not get the right audience within those who are making the law. But we continue to advocate for the inclusion and mainstreaming of customary arbitration, and maybe sometime down the line, we will have a listening ear that will help us out.
Thank you so much, Prof. Thank you. So we're going to try to keep the responses to the questions really short so that we can, because we're really running out of time. We did not intend for this to stretch into 2 hours. So there's a question from Sunday Agonlejika, and I believe it is directed to His Royal Majesty. It is the question is, please, are there examples of cultural rituals which are made to encourage compromise in cultural arbitration?
Interesting question. So we do not carry out any cultural rituals. We don't even use kola nut, for example. Just simply the petitioner just comments the way they state the issues. The person who the complaint is against states his or her side to it, and we resolve it. And once we have an agreement and we get consent agreement by from the monitor court, that's it. That's it. Just shake hands and they or embrace, as the case may be, and off they go. So no, there are no rules.
Okay. Thank you. Thank you very much, His Royal Majesty. There's a question from John Oloyede here. It says, the general rule before superior courts of record in Nigeria is that customary law is a matter of evidence, meaning that it must be proved before the court, whereas it is sought to be relied upon as basis for any claim. Now the question is, in what way can we begin the process of elevating customary law from being a default option in Nigerian courts of record subject to proof to enjoin a pride of place accorded to received English law, equity and statute. I'm sure Prof already highlighted that in his presentation, but Prof, you can just in like a minute give an answer to this.
Well, I think that the easy answer is that we should recognize traditional rulers under the Constitution. That might take a while, but since the Constitution recognizes customary law, we can then ensure that, so there is nothing wrong with updating the AMA to say, look, we recognize customary arbitration, and any party can, there's a section 15A of the arbitration law, which says party autonomy. You can determine the rules that will govern your arbitration. I wish they had added one sentence to that section 15 to say, oh, including customary rules. If that had been done, then that will have let in customary law. And like you said, it could be a default option. Look, we are all this long story. Let's go to customary arbitration. And then that also can be a provision within the EMA.
Thank you for that. Thank you for that quick response, Prof. Then there's a question here that I think you would also be the one to answer, Prof. It says, what happens where a party to the agreement, I believe the judgment from a customary arbitration, fails to honor the agreement and pleads for an extension of time, especially where the matter is standing before the multi-door courthouse?
Well, because I think it's Obama Temilola's lecture that involved the interaction with the multi-door courthouse. Please, if His Royal Majesty can help us with that question. Your Royal Majesty, I said that question appears to be linked to your lecture, sir.
So can you please repeat the question? I kind of missed.
Okay.
Okay.
Yeah, please repeat the question.
Definitely, I will do that. What happens where a party to the agreement, I'm believing that the agreement here means decision from the customary arbitration process. What happens where a party to the agreement fails to honor the agreement and then pleads for an extension of time, especially where the matter is standing before the multi-door courthouse?
Oh, okay, thanks. So normally when we have an agreement by two parties or more than two parties in two cases, and then the multi-door court has already given consent, established. So which now becomes consent agreement. But it has already left the multi-door court essentially. And what that also means, it has a force of the law. Now, because the principle for customary arbitration or mediation is to ensure peace, you could have the party who needs to make restitution, who may be hard-pressed to deliver on whatever the agreement is. We'll still have to find a way, and we've had one or two of such cases, by the way. We just have to appeal. So long as the person does not insist that he or she is not going to deliver on that. If for example, it's a monetary compensation, we'll find a way to manage that between the two parties or parties. If it's about restitution in terms of releasing part of the property, that one is easy to do. And I'll give an example. There's a case where somebody who's a senator of Nigeria, he had already taken a matter, a very important matter, relating to one of the oldest, associations, in West Africa. When it was brought to us, or when we got to know about it, because of the respect he had and his colleague as well for the stool, he just stepped down from the court, and then they agreed to what we had, help them to negotiate in terms of agreements. So usually, except the person is hard pressed in terms of material, restitution, then usually, we try and appeal to them, to their conscience and their good senses. Sometimes we also have it.
Thank you. Thank you so much, His Royal Majesty. I can see a few questions and about the need for continuous knowledge enhancement for traditional rulers. And I'm sure His Majesty has stated and reiterated that there is, at least in his own kingdom, there is always continuous effort to improve the capacity of the traditional rulers who will be adjudicating on these matters, especially as a way to help them merge their existing traditional knowledge with what the law says, so that concerns around human rights abuses and other maybe abuse of law is not does not become something that taints the process that is ongoing. So I believe we've answered that. My Lord Honorable Justice Hume, we are really running out of time, but if you can unmute. Now I've made you a host again, so if you can unmute and in like 1-2 minutes, just address the participants. Yes, that would be very, very helpful. So yes, you can speak, my lord. Just in 1-2 minutes.
Thank you very much. I'm so sorry for the glitch.
Okay, my lord, please go ahead. Okay. I don't know if it's just me, but I don't seem to hear my lord anymore.
Do I go on?
Yes, please, my lord.
Yes,
apologies for that.
Yeah, I thank the former speakers, because Kabeshi, Professor Akinlo So sorry, they have done the greater part of my work. I don't have to go through the history of customary arbitration, which is in existence time memorial before the colonial masters came. The traditional rulers, the elders in the community have been arbitrating on matters like family matters, land matters, even civil wrongs. And
you can proceed, my lord.
Okay. And this is based on the custom and traditions of the particular area. With the coming of independence, the Nigerian Constitution in 1979 recognized customary law. In modern times, 1990s to this present day, the AMA recognizes customary law, but not customary arbitration. It has not recognized it. And the nature of customary arbitration we have is community involvement. The key players are the elders of the community, local leaders, renowned individuals known to facilitate dispute resolution. Customary law of the area is protected and guided and is followed. There's a consensus building. It's party driven and acceptable. And the oral agreements are made, except where they are educated people to record. There's no confrontation is not confrontational, confrontational. This approach is prioritize harmony and community cohesion over strict adhere to formal rules or procedures.
My Lord,
customary arbitration is faster, it's cheaper, it's more accessible than formal courts. The type of customary arbitration we have in Nigeria is conciliatory, mediatory, conciliation, in the sense that it's similar to mediation, but the conciliator plays a more active role in resolving the problem.
My Lord, we would like to start taking your final thoughts at this point so that we can wrap up the session. Thank you, my Lord.
Okay, the challenges have been mentioned in previous. In conclusion, Nigeria accepts the outcomes of traditional dispute resolution mechanisms through validity and recognition. Rules are crafted by judiciary. But in my own case, I take example in Anambra. Unfortunately, the multi-court docket is not developed. Unlike the previous speaker said, customary courts in Anambra are presided by lawyers, not traditional institutes. So that's the problem. Crafting rules of recognition have arisen when parties to a case or Nigerian court to recognize arbitral awards of another legal order as dispositive of the case before the court. For example, when I was in service, there was a case that came to many of them, family matters, land matters. But I noticed that in the evidence there was an arbitration before the chief, the chief or the in the village, and there was the witnesses were taken. They agreed on something. So and then I paused. I said, please go back and get the information. When they came, I noticed that the matter had already been resolved. So what I said, I advised, please get the agreement, let it form part of the judgment of the court so that it will be recognized. And then that was the end of the matter. So what has taken many years just took about 1 week to resolve. So the evaluation of courts or the outcome of customary will remain a barometer of the function of customary. The Nigerian judiciary has to demonstrate the influence of common law in the development of customary arbitration. Over the years, ideas of substantive content of customary arbitration have taken a backseat to issues of procedural validity. What should be a dialectic relationship has turned into a one-way traffic. the capacity of customary arbitration to influence the reform of the legal system seems lost in precedents and legislation. The simple, available, and accessible processes of traditional dispute resolution mechanism, such as customary arbitration, have a lot to offer courts and the common law. The question is,
Thank you.
Whether we are able and willing to harvest these capacities in a manner that we allow courts to encourage customary arbitration. In closing, I will assert that customary arbitration is not inferior law. It is vital source of justice and harmony. Thank you.
Thank you so much. Thank you, my Lord. Thank you. We really appreciate the thoughts you have shared, and thank you for, against all the technical odds, that you are still able to address our participants. Thank you.
Thank you for your patience.
You're welcome,
I'm so
my
sorry.
Lord.
I'm so sorry.
No apologies necessary, my Lord. No apologies. I mean, it's technology, so that's one of the things. There's still that it glitches from time to time, so that's very understandable. Thank you very much, my Lord, for your persistence, that you did not even give up, that you kept trying. Thank you very much. So dear esteemed participants, thank you so much for taking the time and staying with us for this long. We have participants both on Zoom and on YouTube. For the lawyers on the call, kindly check the chat box for the link to claim your CPD certificate. Kindly fill the link and your details. Please note that the link will only be active for the duration of this webinar. And in light of that, because I'm sure a lot of us were really engrossed with the conversation, that we're probably not checking the chats, I am going to leave the meeting room open for another 4 to 5 minutes, so that for those who are yet to fill the CPD link, you can see that. But as soon as the Zoom meeting platform is closed, the link will no longer be accepting responses. So please, I will keep reposting the link. Please fill. This applies only to legal practitioners, please. Thank you so much. On this note, I will be calling on Olachi Oswagu for closing remarks. Olachi, you have the mic, ma'am.
Good evening, ladies and gentlemen. Kindly permit me to lean on the existing protocol. We are so grateful to have you here. On behalf of the organizing committee and the Governing Council of IADR Nigeria, I want to say a profound thank you to our distinguished speakers, to our guest speaker, His Royal Majesty, Professor Saka Matimemela. We thank you so much, sir, for your practical insights. We are so grateful. Kabiesi, may you live long, sir. We also extend our profound gratitude to your Lordship, Honorable Justice Veronica Ume. We thank you so much for being with us throughout. We saw you online. We appreciate your insights. We also extend our gratitude to Professor Kamal. We thank you for bringing out your time for your lecture, for being with us. Thank you very much, sir. And we also extend our gratitude to our own president and chairman of the Governing Council for IADR Nigeria, Professor Akin Ibidabobe. So we thank you so much. Your lecture, you have challenged us to track a way forward in our justice system. But we thank you so much for your time, for your patience and guidance. We cannot also not forget to thank the Garki branch chairman for making this webinar a success, for all the groundwork he's done. That's Barrister Bamidele Ojo. Thank you very much, sir. We appreciate you. We appreciate the publicity secretary for MBA Garki branch, who happens to be our able moderator. Thank you for guiding us throughout the session and for all the underground work you've done. We appreciate you, ma. We also appreciate the Council of Legal Education Department for Garki MBA branch. We say thank you very much for all those who work behind the scenes to make sure that this webinar is a success. We appreciate you so much. And we cannot forget our most esteemed participants who have joined us, who have been patient throughout this webinar and made it an interactive session for your questions and insights. We say thank you very much. And we hope that we'll have more interactive sessions, more knowledge sharing sessions in the future. Thank you much, everybody that has been here following us through this time. Thank you very much and enjoy the rest of your evening. Thank you.
Thank you. Thank you so
Thank
much,
you.
ma'am. Thank you, everyone. And on this note, we have come to the end of this knowledge sharing session, hosted by the Nigerian Bar Association Gariki branch in collaboration with IADR Nigeria. My name is Damilola Victoria Alabi. I am the publicity secretary of the branch, and it has been my pleasure to be the moderator for today's session. Thank you so much. On this note, please, if you're filled the CPD link, you can exit the meeting. And in 2 minutes from now, the meeting will be officially shutting down. So once again, the announcement on CPD points, the link is in the chat box. Please fill the form for legal practitioners before you leave the call, because as soon as this meeting ends, the form will no longer be accepting responses. Thank you so much. And we hope to see you in subsequent sessions. Enjoy the rest of your day. Thank you.
Thank you very much.
Thank you.
Thank you.
All right. In 1 minute, the meeting will be shutting down. So please fill the link for your CPD points as we wrap up. For questions or inquiries about your CPD points from other sessions, you will need to reach out to the MBA ICLE for that. So it's officially close time. Thank you so much once again, our esteemed participants, and we hope to see you.